Thank you for joining us. We're going to get going with today's pro bono training representing asylum seekers. My name is Ashley Hebner, and I'm here with 3 of my colleagues who will all be participating in the training today. They'll wave their hands as we go around. Dahlia, Rachel, and Bea. And we're going to kick things off. So a couple housekeeping matters as we get going. We are going to try to stick to our agenda today. I know it's ambitious and we fully intend to get you out of here at 2:30. We will be having 2 short breaks in case you need to get some more coffee, get some water, stretch in between, and we'll keep that on track. A couple other housekeeping matters before we get started. If you look in your control panel, you will see a tab listed as handouts. In that particular tab, you will see a number of documents related to the training today, including today's agenda, a document labeled NIJC Pro Bono Training Hypotheticals. This is a document you'll want to be able to pull up and utilize as we are talking about some of the hypothetical examples of cases that we're going to go through during the training. We have a document labeled Tools for Pro Bono Attorneys, which is sort of a one-stop shop for all the initial information you may need as you're getting started on your case. And then there's a document labeled Affidavit Writing Tips. This is a document that was actually prepared based on feedback from pro bono attorneys just like you who've been handling asylum cases and wanted to share their experiences and best practices and recommendations for working on an asylum affidavit. So these are documents you can download, utilize later, and utilize them during the training today. At the end of today's training, you will have a link for an evaluation of the training. We really appreciate any comments and feedback you're able to provide. And then after today's training, you will receive an email from us with CLE information as well if you live in Indiana or in Illinois. And before we get started, we also want to share a little bit about other places you can find resources at NIJC if you're taking on a pro bono case. So I'm really quickly going to go from the PowerPoint here, and I'm going to pull up NIJC's website, and I'm going to quickly show that here. Now, NIJC's website is a really great resource for you if you're thinking about taking an NIJC asylum case or if you have one already, and so we strongly encourage you to get familiar with it. You do not need to have any sort of registration to utilize any of our materials. They are all publicly accessible at immigrantjustice.org. If you go to our website and go to the For Attorneys tab, you'll get some really useful information in general about NIJC's resources and upcoming events. So for example, you'll see links to our asylum manual, as well as links to other manuals that we have for different types of cases. If you scroll down, you'll see some examples of the types of cases that we have in need of representation. If you do not currently have an NIJC case, or asylum case that you're representing, we would ask that you take one on within 3 months of this training. And so we will be sharing a case list with you after the training so that you can select a case if you are interested. We have our pro bono spotlights here with information from other attorneys, again, just like you who've been through this whole process and are talking about what it meant to them and how they were able to handle these cases successfully. And then upcoming events. So again, we strongly encourage you to familiarize yourself with this website. We're going to talk about a lot of different information related to asylum cases today. Don't worry about taking copious notes. All of it is in our asylum manual and our website and in other places. But we have a lot of resources that are available for you to utilize in the future. All right, so without further ado, I'm going to kick things off with a little information about NIJC for those of you who are not familiar, and some information about the basics of asylum law. And after that, we'll get more into the nuts and bolts of how you represent an asylum seeker, how you prepare a case, and the various things that you're going to work on today. If you have any questions as we go through, please enter the question into the question tab of the control panel. We may answer certain questions as we go along or save questions for the very end, but we will do our best to cover all of the questions that get asked today. All right, so NIJC is a nonprofit immigration legal service provider. We are based primarily in the Midwest, but we have offices in San Diego, as well as Washington, D.C., and 2 offices in Indiana. We serve more than 10,000 non-citizens each year, and we do this primarily through a network of more than 2,000 pro bono attorneys like you all who are instrumental in our ability to serve so many non-citizens, whether in asylum cases or in other matters. One thing that's particularly unique about NIJC as compared to other legal service providers is we don't simply do direct service or simply do policy and litigation work. We do both. And we think that's really critical because we're able to utilize the information we learn from our direct representation to further our policy and advocacy goals and to ensure that the work that we're doing on a national level really reflects the experiences and the challenges and the obstacles facing our clients on an individual basis. We have a number of different pro bono attorneys at NIJC. Again, today we're going to be talking about asylum, but there are different opportunities if you should be interested in the future, including opportunities to represent somebody seeking citizenship, or to represent an asylee or a refugee who is now ready to seek permanent residency. A special immigrant juvenile status case involving a young person who's able to get status based on being abused, abandoned, or neglected in the past by a parent, or an individual who's seeking status based on being a survivor of domestic violence or other violent crimes. If you're interested in learning more about these opportunities, again, you can go back to that website I showed you, the page for attorneys at immigrantjustice.org, and find out more about those various opportunities. Now, a quick overview in terms of how NIJC's pro bono programs work. So our clients at NIJC come to us in a wide range of ways. And when they connect with us, we do a couple of different things. So we first need to conduct an in-depth legal screening to determine whether they are eligible for the relief that they are seeking, to make sure that they're income eligible for our services, and to make sure that providing them with pro bono representation is going to be a good use of NIJC's resources. If we determine that we're able to accept the case for representation, then we commit to providing representation at that particular time, even though we don't yet know if we're going to be able to find a pro bono attorney to represent the client, which means that if we can't find a pro bono attorney to represent the client, then we are representing the client in-house. And our capacity to do that is quite limited. So you all as pro bono attorneys play a critical role both in ensuring that we are able to provide high volume pro bono representation in asylum cases, but that we're able to continue accepting new cases. Because every time that we are able to place a case with pro bono counsel, that means that we are able to then accept a new case for representation, because that increases our capacity. Once a pro bono team accepts a case, we do not simply say, here you go, let us know when the case is over, good luck. We remain of counsel and we provide support throughout the entire life of that case. And we have a lot of different types of support. So that ranges from the training that you're getting today, to the materials that are on our website, to individual attorney support, document review, and technical assistance. You know, it's really important to us that we take these cases seriously. Taking on an asylum case is a big responsibility. It really is a matter of life and death for many of our clients. And so it's a matter we take seriously. We want you all to take it seriously too. But we also know that as attorneys, you all have the skills to successfully represent an asylum seeker and get that case to conclusion in a successful way where your client is going to get protection and safety and security. Today's training is going to give you some of the first tools to do that. And then the other materials that I mentioned on our website, along with our individual attorney support, are going to help you throughout the life of the case. Now, in case you didn't know, the reason why pro bono attorneys are so critical in these cases is because non-citizens in deportation proceedings do not have the right to appointed counsel. So no matter the type of case, whether it's an asylum case or some other case in deportation proceedings, whether the person speaks English or is illiterate, whether the person is a child or an adult, they do not have the right to appointed counsel. So for many of the asylum seekers that we represent, if they were not able to obtain pro bono representation, then they would have to go forward pro se. And as you'll see here in this chart, the difference in outcome for somebody who is pro se versus someone who is represented is significant. And so as pro bono attorneys, you all are truly making a dramatic difference in the lives of the asylum seekers that you represent. And then, as I mentioned before, when you represent an asylum seeker, you are not simply assisting in the individual case that you took on. You're also making a difference in terms of NIJC's ability to provide representation to other asylum seekers. And if you represent an asylum seeker who has derivative family members from whom they've had to separate in order to seek asylum, once you help them get asylum, they are then able to petition to bring their family members to reunite with them and become on the road to permanent status. So the impact of the work does not simply stop with your individual clients. All right, so we are going to move forward now into the basics of asylum law. As I mentioned, this is just one of the many resources we have. We are going to go through some of this material relatively quickly, and of course we recognize that the legal side can be a little bit more dense than the information about working with your client. But we do think it's important to provide this baseline foundation of asylum knowledge before we move on to actually talking about how to prepare your case and how to work with your client. Again, we have a lot more information about this topic in our asylum manual on our website, which talks in depth about all of the material we're talking about today, all of the case law sites, all of the arguments and legal issues. You'll find more information there. So during today's training, we're going to be using these two hypotheticals to walk through some of the issues that come up in asylum representation. These are hypothetical cases. These are not real clients, but the two claims here are very representative of the types of cases we very frequently see and the cases that you will see on our case list when we circulate that at a later date. So hopefully this will be helpful to you all, whether you take a case in the future or you already have a case that may be involving some of the issues described here. Again, as we talk about these hypotheticals, please pull out the handout, the hypothetical handout in your control panel, because we'll be doing some polls later to have you answer some questions about these hypotheticals. And when you answer the polls, you will not be able to see the hypothetical in the slide. So you will need to pull the handout to do so. All right, so to kick things off, what does it mean to seek asylum? What does it mean to establish asylum eligibility? Where in US law, to be an asylum seeker, to seek asylum, you have to prove that you meet the definition of a refugee. The refugee definition is an international definition. It comes from international law, but has been codified in US law. And the difference between an asylum seeker and a refugee is simply the point in terms of when somebody gets that particular status. So a refugee is somebody who has met this definition. They've established that they're outside of their country of nationality and are unable or unwilling to return to their country because of past persecution or a well-founded fear of future persecution on account of one of these 5 protected grounds. They've met that definition outside the United States. A processing entity, another governmental entity, has established that they meet that definition, and they are coming into a country with the status already of a refugee. And so they have formal lawful status as a refugee when they get here. Asylum seekers, on the other hand, can enter the United States in any kind of way. It doesn't matter how they enter. It doesn't matter if they enter with status or without status. But once they are physically present in the United States, then they seek asylum by establishing that they meet this definition. So they are seeking to establish that they meet the definition of a refugee while in the United States. It's an important definition to also keep in mind because refugee is a technical legal term. Now, we've all been hearing a lot about the Afghan parolees or the Afghan evacuees who've been coming into the United States since the United States left Afghanistan. And a lot of times, a lot of the news media has been referring to them as refugees, but technically speaking, that is not accurate. They did not enter the United States with the formal lawful status of a refugee. They are refugee in sort of the vernacular way we use that term, but they do not have formal lawful status as a refugee. Those Afghan individuals, like many others who come to the United States, will ultimately need to seek status here in order to get protection. And when we're trying to understand what that refugee definition means and what it means to establish asylum eligibility, we're going to be looking to 3 different sources. Immigration law is administrative law, so we're going to be looking to the statute, but the regulations are really, really important, and we're going to be looking to case law. When we look at case law, we are primarily looking at decisions from the Board of Immigration Appeals. That's the administrative appellate level in the immigration system, but we are also looking to the 7th Circuit, and we're looking heavily to the 7th Circuit. The 7th Circuit has just an absolute bounty of asylum case law. And there's also often a very difference in opinion between 7th Circuit case law and Board of Immigration Appeals case law in a way that is very useful and helpful to our asylum clients. So you want to be paying very close attention to 7th Circuit case law. The 7th Circuit is your friend. You do not want to be citing to circuits outside of the 7th Circuit generally, because the 7th Circuit is where the good law is and where most of the law exists, and it's what's going to be binding on your case and on the adjudicators at the Chicago Asylum Office and the Chicago Immigration Court. There are two other forms of protection-based relief we're also going to talk about today. We're not going to spend a great deal of time on them because generally speaking, most of NIJC's clients will be seeking asylum as their primary form of relief and not these other two forms. But it's also important to keep in mind that when clients seek protection in the United States, they are really seeking three different forms of relief. Asylum is the first form. The second form is called withholding of removal. The withholding of removal definition is similar to the asylum definition, but it's a bit different in terms of burden of proof and the benefits that you ultimately get. Somebody who is granted withholding of removal really gets what the title says it is. Their removal is being withheld. Full stop, that is it. They don't get all the benefits of an asylee, but they still get the protection of being able to remain in the United States and not being deported to the country where they fear harm, and that's very important. When you seek asylum, you automatically seek withholding of removal without having to take any additional steps. The third form of relief is called relief under the Convention Against Torture. This is a bit different than asylum and withholding of removal. The definition is different. It talks about torture instead of persecution. It talks about torture that is with the consent or acquiescence of a public official, rather than by an entity the government is unable or unwilling to control. And like withholding of removal, it has a higher burden of proof than asylum does. But for some of our clients, this is the best form of protection that they can get. And again, it prevents them from being returned to a country where they would be tortured. So it's an important form of relief. When you seek asylum, you can also very easily seek relief under the Convention Against Torture by checking 2 additional boxes on your asylum application. When we talk about the differences between these, here's a quick chart just to show some of the differences between these 3 forms. So asylum is a discretionary form of relief. So one of the reasons some of our clients may not be eligible for asylum, but would instead seek withholding of removal and CAT relief is because as a matter of discretion, or in some case because of a bar to asylum, they're not going to be found eligible for asylum and would be seeking these other 2 forms of relief instead. As I mentioned, the burden of proof is different. For asylum, it's a reasonable possibility, a greater than 10% chance, or a 10% chance of persecution. With withholding of removal and CAT relief, it's a more likely than not burden of proof. And as I mentioned, for withholding of removal and CAT relief, the benefits are not the same as they are for asylum. When you get asylum, you can petition for derivative family members. You can travel abroad. If you wish to go to college, you're eligible for federal financial aid. You are on a path to permanent residency and eventually citizenship. With withholding of removal and CAT relief, you are simply allowed to remain here and you can't be deported to the country where you would be harmed, but that is it, full stop. You are not eligible for any of these other benefits. You can't petition for your family members. You can never get citizenship. So a far inferior form of relief. However, for some of our clients, it is their best option to stay here in the United States. Again, we're not going to talk much more about that at this time. There's more information in our asylum manual. And if you have a particular case where you think your client is only going to be able to seek withholding and CAT relief, you can reach out to us about that and discuss that in greater detail. Now, we often get a lot of questions about what has changed in the past 4 years, moving from the Trump administration to the Biden administration. And practically speaking, under the Trump administration, while it was a very terrible environment for immigration as a whole and for non-citizens in the United States, here in the Chicago Immigration Court, we didn't see dramatic changes in the way asylum cases were being adjudicated. And a large part of that was because Seventh Circuit asylum law remained consistent and remains strong. However, we have seen some changes in terms of the judges who are on the bench in the Chicago Immigration Court, some of the decisions certain judges were issuing, and then of course there were a lot of changes in case law at the Board of Immigration Appeals and Attorney General level, and some attempted changes in immigration regulation, which impacted things as well. The biggest changes I would say that we've experienced here was the procedural confusion and the backlogs. We'll talk a little bit more about timing as we go on, but there has been extensive procedural confusion about how cases proceed, when cases are going to proceed, when to expect that a client's hearing or interview will be rescheduled, and all of this also has been impacted by COVID. So generally speaking, asylum law remains good and remains strong here, but overall, there's a lot of uncertainty that remains, and we will see how things proceed in the coming year as this is impacted both by the change in administration and by the situation with COVID. All right, so we are now going to dig further in and talk a little bit more about the elements of asylum and what you really need to prove. You know, what we're going to talk about now is what you are going to put in your brief or your memo, how you are going to argue your case, what you're going to need to establish in order to get your client asylum. All right, so at the very beginning, we talked about the refugee definition and what the refugee definition meant and how in order to get asylum, you have to meet that definition. Well, to get asylum then, we break that refugee definition down into 5 different elements. These 5 elements are the basis of your entire asylum claim, and you need to keep all of these elements in the back of your mind while you're preparing your case. In your affidavit, in your corroborating evidence, in your memo, in your brief, you need to always be thinking about these 5 elements and how the evidence you're presenting, how the arguments you're presenting are establishing these 5 elements. It's also really important to understand that these elements are separate. So we have well-founded fear of persecution perpetrated by the government or an entity the government cannot or will not control on account of one of these 5 protected grounds. These elements are separate, which means your client could establish that he or she suffered persecution but still not get asylum if he or she can't show that that persecution was on account of a protected ground. Your client could belong to a particular religion, but if your client can't prove that the persecution she suffered was on account of that religion, then your client is not going to be eligible for asylum. So it's really important to keep in mind that these are separate. An example we often provide of a way that the elements can be conflated in a damaging way for asylum seekers is the Seventh Circuit case, where the Seventh Circuit said that rape is persecution if it's inflicted on account of a protected ground. In that particular statement, the Seventh Circuit conflated the definition, the element of persecution, with the on account of and the protected ground elements. Rape is persecution because of the particular type of harm it is. That is irrespective of why it was inflicted and whether that reason was on account of one of the protected grounds. And so it's really important to keep that in mind, that each of those elements needs to be established and analyzed separately. All right, so working through this the first element here, well-founded fear. So well-founded fear is the burden of proof in an asylum case. And the Supreme Court has held that the burden of proof for well-founded fear is reasonable possibility, which is a 1 in 10 chance of persecution. That's relatively low, but you are establishing a 1 in 10 chance of persecution that is going to happen in the future. And that's why these cases can be challenging. Fortunately, the regulations say that you can establish this well-founded fear, this 10% chance of persecution, in one of 2 ways. Either showing that your client has been persecuted in the past on account of a protected ground by the government or an entity the government is unable or unwilling to control, and then you can get a presumption of future persecution, or by showing a future fear only, showing that in the future, there's at least a 10% chance that your client is going to be persecuted and that such persecution would be on account of a protected ground by the government or an entity the government is unable or unwilling to control. Because you will get this rebuttable presumption if you establish past persecution with all of the asylum elements, but you can still win asylum even if you don't. It's important to argue both whenever you can, past persecution and a well-founded fear of future persecution. So breaking this down a little bit further, if you are establishing a well-founded fear based on past persecution, so you have to show past persecution and all of those other asylum elements, you get a rebuttable presumption of future persecution. At that point, the government can only rebut your well-founded fear by either showing that there's been a change in circumstances such that you no longer have a future fear, or by showing that your client could safely and reasonably relocate internally within their country of citizenship. If they can't prove that, then your client has established asylum eligibility. Now, if you have a future fear only case, meaning your client has not been persecuted in the past, maybe your client was able to leave the country before things got really bad, or maybe circumstances changed in the country after your client left. Your client is still able to get asylum, but now you have to show it in a slightly different way. So you have to show that your client has a subjectively genuine fear, basically that your client is credible, and an objectively reasonable fear. And that objectively reasonable fear connects with the reasonable possibility. So your client's future fear is objectively reasonable if there's at least a 10% chance that your client will be persecuted in the future on account of a protected ground by the government or an entity the government is unable or unwilling to control. If that's the case, if your client proves that, then your client must also show that internal relocation in their country of citizenship is not safe or reasonable. So keep in mind, there's a slight burden shift there. In past persecution, the burden is on the government to rebut the presumption by showing internal relocation is safe and reasonable. For a future fear only claim, the burden is on you to show that internal relocation is not safe or reasonable. If you establish all of these things, then irrespective of what happened in the past, your client has established a well-founded fear of future persecution and is eligible for asylum. Now, there's one other way that you can get asylum if you have established past persecution and all of these asylum elements as to the past, but the government has rebutted your future fear. Maybe circumstances in your country have changed. Maybe your client could relocate at this point in time to avoid persecution. The judge or the asylum officer is still able to grant asylum in that case if your client can show one of two things. Either that the past persecution your client endured was so severe they should not be compelled to return, or if your client can show a reasonable possibility of other serious harm in the home country. What's important here is to keep in mind the differences. These are two different ways to establish asylum on a humanitarian basis. For the severity of the past harm prong, it has to be quite severe with a long-lasting impact. Some of the cases on this particular prong involve an individual whose entire family was severely impacted by the Cultural Revolution in China, and the applicant had ongoing mental health issues as a result. Another example would be a woman who experienced a particularly horrific form of female genital mutilation. So that can be a challenging prong to meet, but in some cases it certainly can be met. The other prong is a little easier because you're simply showing a reasonable possibility of other serious harm. So this could be, the fact that your client is going to go back to a war-torn country. Maybe they're not going to be experiencing harm on a kind of a protected ground, but they are still more likely, there's still at least a 10% chance they will be harmed in the future because of the conditions in the country, or because there are severe health concerns. Sometimes you might want to look at the COVID implications, or because your client needs medical care or mental health care that won't be available in the home country and your client will suffer harm as a result. Those are all things to keep in mind. This is an important argument to make, and it's one that we recommend including in every single asylum place where there has been past persecution. All right, so that's the first element, well-founded fear. The second element is persecution. Persecution is not defined in the regulations or the statute, so you have to look to case law. Fortunately, we have a really great decision in the Seventh Circuit, Stanjakova, which provides 3 different types of harm that rise to the level of persecution. They talk about significant physical harm, so the type of persecution we would typically think of, the infliction of comparable physical harm without the direct application of force. So this could be throwing somebody in prison without food or water for a week. That could rise to the level of persecution. And non-physical harm of equal gravity. This third one is an important one to keep in mind because it's a bit of a gray area and is something that hasn't been fully fleshed out within the Seventh Circuit. But non-physical harm of equal gravity, they provide the example of someone who's not able to practice their religion. And they also provide the example of psychological harm, for example, credible, imminent, and serious death threats. So this is really important to keep in mind. We use this third prong when making arguments, for example, in sexual orientation or gender identity cases where an individual was not able to be out in their home country, and argue that that is non-physical harm of equal gravity. We've made this argument in the context of gang cases where a child was unable to go to school because of the particular gang situation, and argue that a child not being able to access a primary education was non-physical harm of equal gravity. So again, you can be creative there. Remember, you want to make that argument of past persecution whenever you can. And when you're making those arguments, look to Stanjakova. Don't cite to other case law. This is the best example you have. You don't need to throw a whole bunch of string cites in there. Just look to Stanjakova, use these 3 examples, and argue that your client has established persecution. 2 other things that are important to keep in mind. The harm constituting persecution can be less for a child than for an adult. And that's even the case if your client is an adult now, but experienced harm as a child. So if you have that type of case, whether your client is a child now or experienced harm as a child, you want to make sure to include that argument that you need to look at the impact on your client based on the fact that he was a child when determining if it was persecution. And then finally, harm must be considered cumulatively. So the judge, the asylum officer, is obligated to look at all the harm in the aggregate when determining whether it rises to the level of persecution. All right, so we are now going to take a little break from the training itself and use a poll here to walk through what harm might constitute persecution. So again, I'd recommend pulling up that handout so that you can have the example of the hypotheticals in front of you. And I'm going to initiate the first poll here. All right. So you all should be seeing the poll that is asking some questions for Christopher about what you would need to know, what facts are important when determining if Christopher suffered past persecution. So take a few minutes, please answer the poll, and then we'll show the results shortly. All right, we'll do 5 more seconds. All right, we are going to close the poll and we will share the results. Okay, so let me just pull this up here. So most of you thought the most important factor here was to determine how the cartel tried to force him to work. And I think that's the correct answer. But it's important to think about where these other answers come from. So the question of whether the cartel threatened him after he left could be very important for establishing whether he has a future fear of persecution. But when we're looking about whether he suffered persecution in the past, we're looking at what happened in the past and determining what facts were relevant there. So how the cartel tried to force him to work is important, because right now all we know is they tried to force him to use his truck. We don't know what that force entailed. Did they threaten him? Did they threaten him at weapon point? Did they beat him? Did they threaten his family members? Those are all going to be important facts in order to determine whether he had been persecuted. The question of whether the cartel is connected to the government is important for another asylum element, the unable or unwilling to control element, but it's not critical or really that relevant to the question of whether he suffered past persecution, because again, these elements are all separate. All right, I'm going to remove that poll and we are going to go back to the slideshow. All right, so we have now talked about well-founded fear of persecution, and we're moving on to the third element, which is the persecutor, which we just briefly talked about. So in order to get asylum, it's not necessary that the persecutor be a state actor. If the persecutor is a state actor, that certainly simplifies your argument, but it's not critical. In most of the asylum cases we have nowadays, the persecutor is a non-state entity. And so what we're trying to establish is that this entity, the persecutor, was an entity the government is unable or unwilling to control. Either or is fine. It doesn't have to be both unable and unwilling. And so we will be looking at the various factors, the country condition evidence, the testimony from the client to establish that the government is unable or unwilling to control. And this is an important part of your affidavit preparation, of your interviewing with your client, to find out why couldn't they get protection from the government? Why were the police ineffective? Did they make a police report? If they didn't, we certainly need to know why, because it's going to be more difficult to show the government was unable or unwilling to control if they never tried to get governmental protection. Although in many cases, there's great evidence to show that it would have been futile and it would have been unsafe for them to do so. So these are all important factors to sort of flesh out, but it's important to keep in mind that it is perfectly fine in an asylum case for the government not to be the persecutor, for the persecutor to be a non-state entity. And we have a lot of information in our manual, and we'll talk a little bit more later on how you meet that element. All right, so we've done well-founded fear of persecution by the government or an entity the government is unable or unwilling to control. So now we're moving into the last two elements, which are typically the most difficult in asylum cases. Nexus, the on account of element, and the protected ground. So In order to establish asylum, you have to show that the protected ground was at least one central reason for the persecution. It doesn't need to be the central reason, just at least one of the central reasons for persecution. The persecutor can still have mixed motives, and in fact, the Seventh Circuit has said it's fine for the protected ground to have been even the secondary or the tertiary reason for persecution, as long as it was not ancillary to a central reason for persecution. Really important to keep that in mind, because in most cases, the persecutors will have mixed motives. Circumstantial evidence can also be sufficient to establish motives, because in most cases, you are not going to have a letter from the persecutor explaining why they are harming your client. Now, sometimes you will have evidence similar to that. You may have a threatening letter. You may have a threatening text message. Those are always really important things for your clients to save whenever possible. But circumstantial evidence is more than sufficient to establish the persecutor's motives. And so when we talk about all the evidence we're looking at for Nexus, we usually group this into three categories. You have the direct evidence, the words, the action, the timing. You have the circumstantial evidence, which could be, how does the persecutor normally act? Who are the typical people that the persecutor targets, and why do they target them? The context surrounding the particular situation. And then you have country condition evidence. Country condition evidence is very critical. We'll talk more about it in the preparing your case section, but that's a key part when trying to establish Nexus. So keep in mind, again, that these three elements, persecution, on account of a protected ground, and the Nexus element itself, are all separate. Somebody can be persecuted, but that persecution may not be on account of a protected ground. Someone may be part of a protected ground, but they may not have been persecuted on account of that protected ground. When adjudicators conflate elements to the detriment of the asylum seeker, it is usually conflating these three elements. One way you can help prevent that is by keeping these elements very clear and very separate in your memo, in your brief, in your oral arguments. We have template briefs on a number of specific cases that we typically see involving domestic violence and gang-based claims that lays out very clearly the framework that you should use to present these cases. All right, so we are now moving into the final element, the protected ground. We often hear asylum being referred to as political asylum. We don't really like that terminology because it tends to sort of limit the view of who's eligible for asylum. Nowadays, most of the asylum seekers we are seeing are not seeking political asylum. They are seeking asylum for other reasons. So these are the 5 protected grounds on which you can get asylum. Race, religion, and nationality are all very straightforward and fairly self-explanatory. We see these, sometimes we see them mixed up together and overlapping in the claims, but we don't see these claims quite as frequently. Political opinion is also fairly straightforward, although again, it's important to keep in mind that a political opinion claim could be based on your actual or your imputed political opinion. So something we often will see is an imputed political opinion where somebody is maybe a family member of somebody who's political, and the government imputes that political opinion to them because of their family membership. Or maybe they live in a particular area that is perceived as being affiliated with a particular opposition group, and they are tagged accordingly. Sometimes it's even the very fact of having lived in the United States that for certain countries will give rise to an imputed anti-government, in their country of origin, anti-government political opinion. So that's important to keep in mind. However, membership in a particular social group is the most common basis for asylum nowadays, and because of that, it has become the most controversial. It was really the focus of many of the extremely anti-immigrant decisions that came out of the Attorney General under the Trump administration, and it remains a very complicated area of asylum law today. So what is a particular social group? So particular social group is not defined in the statute or regulations either. And so what the Board of Immigration Appeals did back in the 1980s was to define it, to create the definition of a particular social group by looking at the other grounds for asylum. And they looked at race, and they looked at nationality, and they said these are 2 characteristics that people cannot change about themselves. They're immutable for that reason. And then they looked at religion and political opinion and said these are 2 characteristics that people should not be required to change because they are so fundamental to their identities. And they said, therefore, to be a member of a particular social group, the group has to be based on individuals who share a common immutable characteristic that either they can't change, like race and nationality, or they should not be required to change, like political opinion or religion. And that was really the definition that was in place for about 2 decades. But then as we started to see more and more asylum seekers coming from Central America, and most of those claims involved particular social group claims, we started to see consecutive administrations try to crack down on particular social group-based asylum in order to restrict the number of asylum seekers from Central America and Mexico who would be able to get asylum in the United States. So the Board of Immigration Appeals has now restricted case law and restricted the definition to also say that a particular social group must be socially distinct and particularly defined, while creating a lot of confusion about what those 2 additional requirements actually meant. This has led to significant litigation across the country. Fortunately, here in the Seventh Circuit has not formally deferred to these new additions to the particular social group definition and has issued a number of cases which say, no, we are only following this common immutable characteristics test, which is very good for us here in the Seventh Circuit, but it's also continues to be on very shaky ground. And it's also shaky before the Chicago Asylum Office and the immigration judges, where not everybody is fully on the same page about the state of the case law in the Seventh Circuit. We do entire training simply on particular social groups, so we're not going to get into great detail here. I will flag that we have a very recently updated practice advisory on particular social groups, which is available on our website. I strongly recommend you take a look and familiarize yourself with the issues involved here if you have a case involving membership in a particular social group. All right, so we are going to do another hypothetical here and talk about the protected grounds. So give me 1 second. If you want to pull up your handout, we're going to talk about Norma's claim. So what protected grounds are likely the basis of Norma's claim? This one might be a little simpler, so I'm going to give you a short, maybe 20 seconds to quick answer this question. It looks like we have a unanimous result here thus far. I'll give you 5 more seconds to answer. Oh, not quite so unanimous anymore. All right, I'm going to close the poll so we can discuss really quickly. And I'm sharing the results. Okay, so we have a claim here that involves a domestic violence-based claim and some gang issues as well. And so generally, this is primarily going to be a particular social group claim. We are going to be arguing that Norma was being targeted because she was a woman. In a relationship that she could not leave, or a relationship where she was being viewed as property, or because she was in a relationship where she was violating the gender norms of her community and she was being targeted accordingly. With the gang issue, we would typically argue that this is a family-based particular social group. She cannot change her family connection to Carlos because they have children together. And that's an immutable characteristic. There may be other protected grounds here. So I see some people selected nationality as a particular ground. We would often combine nationality with gender here and say that Norma belongs to the particular social group of Salvadoran women. Those are certainly 2 characteristics she cannot change. And we don't have a lot of facts here either. So it's also very possible that there were other issues at play. Maybe there was a religion angle here. Maybe some of the abuse involved because Norma was very religious and Carlos was not, or vice versa. There could also sometimes be a political opinion claim in these cases. It may be that Norma was very vocal and adamant in her views of how she thinks women should be treated and the rights she believed women should have, and the abuse would often occur in response to that. We don't know all those facts, but generally speaking, the primary protected ground here would be a particular social group. All right, I'm going to hide that poll and we're going to do one more related to Norma. What facts are important to defining Norma's particular social group? And so we talked a little bit about this, but I'm going to launch this and we'll give everybody maybe 25 seconds to answer. All right, 5 more seconds. It's like a lot of people have not voted yet, so get your votes in. All right, we're going to close the poll. And I will share it now. All right, so there are going to be a lot of important factors to consider when trying to figure out exactly what were the characteristics that gave rise to Carlos persecuting her. What was it about Norma in particular that created the persecution? And we understand, of course, that this is sort of a bizarre question to even be asking. You know, asking what about this situation motivated Carlos to harm her is a bizarre and kind of uncomfortable and difficult question to even ask. But here, we're going to look at her gender for sure. I think in a lot of the cases we see out of Central America, we will see a lot of evidence, both from our clients and from the country condition documents, that will say that in the client's community, domestic violence was common, and it often happened because women were perceived to belong to either their fathers or to their partners, and that within those relationships, the men could treat the women as they wished, as their property, because they believed they had the right to control them however they wanted. That domestic violence was often viewed as an acceptable means of punishment for particular actions within a relationship. So at its base, we say these are gender-based claims. These are claims where Norma is being harmed because she is a woman in El Salvador. That is the fundamental reason why she is being harmed. But there's some other factors here too. So the relationship to Carlos is most certainly going to be important. Most likely, and in most of these cases, Carlos is not just beating up and abusing any woman he sees on the street. He is specifically abusing Norma because of the relationship, because he believes he has the right to do that, because there are maybe certain norms, whether they be legal, cultural, religious, or otherwise, that cause him to believe within the relationship he has the right to do that. So that relationship is also going to be important. Now, we have a separate gang-based claim here. So Carlos having witnessed a murder and now Norma possibly being at risk because of her relationship to Carlos, that's also important as well. That is a separate part of the claim here, but their relationship and the risks that exist because of what Carlos witnessed are also important for formulating a separate particular social group. So it might be family members of Salvadorans who have witnessed gang crimes, for example. Those are immutable characteristics because family membership can't be changed. Carlos can't change the fact that he witnessed the gang murder. That is immutable by virtue of the fact that occurred in the past. Excuse me. The one thing here that we don't want to be part of the social group is the fact that Norma is a survivor of domestic violence, because Norma is not being abused because she's a survivor of abuse, right? That's a circular argument there, and it's a circular argument that can become quite problematic. First of which is because case law is clear that the social group cannot be defined solely by the persecution itself. So if you presented a social group that was Salvadoran women who are survivors of domestic violence, and the persecution you are arguing is the domestic violence, that is a circularly defined particular social group, okay? It's also going to be difficult to establish nexus because you're going to have to show that she was harmed because she was harmed in the form of domestic violence because she's a survivor of domestic violence. So your nexus argument there is also quite circular. So you want to make sure and keep that out of your particular social group definition. Now, there are certainly situations in which the fact that somebody was harmed in the past could give rise to a new form of persecution in the future, but then you don't have a circular definition because the harm in the social group is different from the harm your client fears. So that's really important to keep in mind. So the correct answer here is the last one, A, B, and C. Her gender, her relationship, and Carlos witnessing a gang murder are what are most important. All right, we are almost done with the legal section. So a few other considerations to keep in mind. There are a number of statutory bars to asylum. We're not going to go into great detail into all of these. They are discussed in our asylum manual. But it's important to keep these in mind. And it's important to, I'm gonna realize we moved along. Let me just close this here. Looks like folks are not able to see the PowerPoint yet. Hold on. See if we can close this poll out. Sorry about this. All right, 1 second. We'll try to get it going, and if it doesn't, we'll move along in a second. All right, it looks like the poll is stuck. I am very sorry for this. We're going to move along. I'm going to keep talking, and hopefully you can pull up. I'll be able to show this a little bit later. I'm not quite sure why the poll is not showing here, but or the screen is not showing, but hopefully you'll be able to see it shortly. So we're going to talk about bars to asylum. So there are a number of bars to asylum. Like I said, they're mostly in our asylum manual in greater detail, so we're not going to go into them in great detail here. But one thing we want to sort of keep in mind is two ways these things come up. So first of all, there's a 1-year filing deadline, and that's very important to keep in mind that asylum applications have to be filed within 1 year of entry. So I think, you know, that's really important to keep in mind, and we flag this when you take a case. We flag the filing deadline. The 1-year filing deadline, if you do not meet it, you could be prevented from being eligible for asylum. So that's really important to keep in mind. Some of the other bars involve things like terrorism risks and the Persecutor bar and criminal related bars. And the reason we want to keep those in mind is because sometimes these come up in different ways. And as an example, I want to sort of flag what we are keeping our eye out for Afghan asylum cases. So again, we've all seen in the news that, you know, all the numbers of asylum seekers coming here from Afghanistan, or I should say all the numbers of evacuees and parolees coming from Afghanistan. And as I mentioned earlier on, they are not coming in with the formal status of a refugee. They are going to need to seek some form of permanent status, and some of them may decide that they want to seek asylum and they may be eligible for it. But under the terrorism bar, which is a very broad-based bar that's set out in the statute, somebody could be ineligible for asylum because they had previously been forced to provide some kind of support to a group that used violence in their home country. So for example, if somebody was in Afghanistan and had to pay some kind of war tax or extortion money to a local militia group, that could subject somebody to the terrorism bar and make them ineligible for asylum. Or if somebody's family member was kidnapped and they had to pay, you know, some ransom amount, that could subject them to the terrorism bar. And so these are really important things to keep in mind, that facts that may otherwise, you know, make your client think that they are certainly eligible for asylum because of that harm, because they were extorted, because they were threatened with harm if they didn't pay that ransom, that's a good asylum fact. It could actually create serious concerns in their cases. So these are things we will always flag in advance when we're doing our intakes before we refer cases to pro bono attorneys, but they're also important to keep in mind. And again, I'm sorry, we're still experiencing this difficulty here, but we'll have a break very soon and hopefully be able to fix it during that time. And we're almost at the final slide. So the last slide here that I'm going to talk about that I know you all cannot see right now is that sometimes there's other issues that may not bar asylum, but that could still impact the case. And these are important to keep in mind. These typically relate to life changes. So for example, there may be certain events in the client's life that could make them eligible for other relief. So a client could get married, and sometimes, although not always, that may make them eligible for a family-based immigration petition. That's often seen as more easy than it actually is, but it could be possible. If your client is a victim of a crime, they could be eligible for a different type of visa. So it's really important that you let your clients know in advance if you are anticipating making any life changes, like getting married, like moving. They talk to you first, so you can talk to us and we can advise on whether that is something that may impact the case in a good or a bad way. If your client is a victim of a crime, they should certainly let you know so we can advise on that. Your client absolutely should not be filing any immigration applications without consulting with you first, because anything that is filed could impact their asylum case. Some of these same changes could also compromise eligibility for relief. So crimes, as we talked about, even if they're unconvicted crimes, even if it was criminal activity for which your client was never arrested, we need to know about those things. If your client travels, your client cannot travel internationally while their asylum case is pending, but sometimes even travel near the northern or southern border can create certain risks. And so before your client is going to travel anywhere outside of the Midwest, they should talk to you first. We can talk to you, explain the potential consequences, and you can have that conversation. So in our experience, it's important to flag this before these situations arise. So when you're first meeting with your client, let them know if you're contemplating making any life changes, or if you have experienced a significant change, let me know. And then every time you talk to them, remind them of this again, because the last thing you want is to find out about a significant move or marriage or criminal situation months after it occurred, when it may be very difficult to resolve. All right, we are done with our first section. And again, I apologize for the technical issues, but we should have this fixed when we move to the next section. We are going to take a 5-minute break. So we will be back right at 1 o'clock, and we will get started on how to get started and work with your case and represent your asylum seeker. Thank you.
All right. Hi, everyone. So we are back. It is 1 o'clock. As Ashley mentioned earlier, I'm Rachel Milos. I'm one of the attorneys on the asylum team. And I'm going to start talking to you today about getting started if you decide to take a case with NIJC. So in the asylum system, there's really 2 different ways that individuals can seek asylum. There's an affirmative posture, and this is for individuals who are not in removal proceedings. So for example, this would be someone who entered the United States on a visa, on a tourist visa or on a student visa. They came into the United States, and then after they arrived in the United States, they decided that they wanted to apply for asylum. For these individuals, what they're going to do is they are going to file their asylum application with USCIS, which is United States Citizenship and Immigration Services, and then they are going to have an interview at the asylum office. There are also individuals who are seeking asylum defensively. So this is for individuals who are in removal proceedings already. And this would be for an individual, for example, who presented themselves at a port of entry, and they basically expressed a fear of return to their home country at that point. When they came into the United States, they were issued a document called a notice to appear, which is a charging document that placed them into immigration court proceedings. And then what they will do is they will go into immigration court. They will admit to the judge that they are removable, but they will assert that they are eligible for asylum, and this is their defense to removal. What they will do is they will be in immigration court, and they will have a hearing before an immigration judge. If individuals are unsuccessful in immigration court, there is an appellate process, so they will be able to appeal their case before the appellate court in immigration land, which is called the Board of Immigration Appeals. And if they are unsuccessful in front of the board, then they will be able to petition the 7th Circuit Court of Appeals for review of their case. Now, there are a number of different individuals that are involved in the asylum system. So we use this slide kind of just to let you know that if you take an asylum case and you get involved in immigration cases, there are a lot of different players. One of those players is going to be immigration court and the Board of Immigration Appeals, which I just mentioned, which is under the umbrella of EOIR, which is an acronym which is short for the Executive Office for Immigration Review. This is going to be, again, if you're representing a client who is in removal proceedings. You're also going to come into contact with an organization called USCIS, United States Citizenship and Immigration Services. This, again, would be if your client was proceeding affirmatively. So your client came in on a valid visa, decided to apply for asylum, and then was going to have an interview at the AO or the asylum office. If you're assisting your client with a work permit, or you're filing a Freedom of Information Act request, or you need to submit a request for your client to get fingerprinted, you'll also come into contact with USCIS because you will file those applications with them. Some of our clients, when they came into the country, were detained by ICE, Immigrations and Customs Enforcement, or by ERO. And sometimes they've had an ankle monitor placed on them. And so oftentimes they'll have a check-in with ICE where they need to go in and check on that ankle monitor. Or a lot of times we do advocacy to get those ankle monitors removed from our clients. So you may be involved in some of those types of things along the way. And then CBP is just another organization, Customs and Border Patrol. We also list at the bottom, some of our clients are children, so they enter without parents or legal guardians. If children enter alone, they're designated unaccompanied immigrant children, and they are placed in shelters that are housed under the umbrella of ORR, which is the Office of Refugee Resettlement. And then finally, you know, our clients, their families, and the attorneys that represent them are important pieces of this puzzle. So this is just to kind of give you a lay of the land and acquaint you with some of the different players. Sorry, I'm struggling with my slides here. All right, so when you decide to take a case from us, we're going to ask you to do a couple of things. One of the first things that we're going to do is we're going to give you a case file. And in that case file, we're going to have a number of things. The first thing is going to be a cover letter. And on that cover letter, we're going to let you know who your client or clients are. We're going to give you all their contact information. We're going to let you know the procedural posture of the case. So is your client in removal proceedings? Is your client applying affirmatively for asylum? We're also going to flag some important deadlines. So does your client have any upcoming court hearings? Does your client have a work permit yet? Is your client going to become eligible for a work permit soon? In which case we'll ask you to assist them in applying for that work permit. And then we're also going to flag some steps in terms of what forms need to be filed. So in certain cases, clients need to be fingerprinted. You'll have to submit a request for that. In other cases, we're going to ask you to file a FOIA request to get information about their contacts with immigration officials. And so we'll list all of those things out in the beginning of the file. In addition to that, we're going to give you all the forms and all the documents that clients provided to us when they came in for their intake interview. So if they brought in passports, if they filed police reports back in home country based on their asylum claim, and they brought those copies of those police reports with them and gave them to us, we will give those to you. If they have photographs of any injuries that they took, we will forward those along to you. And then finally, we will give you all of our case notes. So when clients first come to us, as Ashley mentioned, we'll do an intake interview where we'll talk with client for a couple of hours to assess their eligibility for asylum. And we'll have just a whole bunch of case notes about that, why we found them eligible for asylum, what grounds we think they're eligible to apply on, and then any communications that we've had with clients after that point. So all of those things will be provided to you because we want you to know what we know about clients. So the first step would really be to review that file. Next thing we'd ask you to do would be to file your appearance. So depending on the posture of your client, you're going to either file a G28 or you're going to file a form called an E28. So if your client is in removal proceedings, so they're proceeding in immigration court, you're going to have to file a form called the E28. And the E28 is a form that you're going to file, which allows you to enter your appearance in immigration court. Before you do that, if you've never filed an E28 before or practiced in immigration court before, you are going to have to get an EOIR number. That's kind of like your attorney registration number that allows you to practice in immigration court. And there's a brief registration process you need to take care of before you can file that E28. So we'd recommend that you take care of that first. Or if your client is not in removal proceedings and they're proceeding at the asylum office, then you're going to file a different form that is called the G28. And you're going to file that with USCIS and the Chicago Asylum Office. Now, if you're filing it along with the I-589 or the asylum application, that's great. If the I-589 has already been filed, then you can file your G28 directly with the Chicago Asylum Office. So in addition to those steps, another thing we're going to ask you to do is calendar all deadlines. This is something we take really seriously at NIJC because it is so important to our clients. So one thing you're going to want to calendar for sure is, does my client have any upcoming court hearings? Really critical to write those down because clients have to appear at those court hearings. If they do not, they can be ordered removed in absentia, and we do not want that to happen. So definitely calendar those dates. In addition, employment authorization, getting a document that allows clients to work legally in the United States is critical to our clients. And so really writing down that date that they become eligible or writing down those dates that you can renew their applications will be really important to them. Another thing that we'd recommend, because COVID has really thrown the court into a state of flux and dates are changing and hearings are getting canceled routinely, we'd recommend that you check the EOIR automated system, which is the court's sort of automated hotline number, or there's an automated information page online where you can check on the status of your client's hearing by just entering their A number, which is a 9-digit number that is tied to them. So if you just enter that number into their automated system or you call their hotline number to check on the status of your hearing, we'd recommend doing that every week or every couple of weeks just to make sure that the hearing dates have not changed. In addition, as I mentioned before, filing a FOIA request, a Freedom of Information Act request, is really important because we want to know if our clients have had any contacts with immigration officials when they entered the country. We want to know what they said, what happened in those interactions, so that we can cross-check those statements with the statements that we are going to be submitting in their affidavit in our supporting materials. So definitely filing that FOIA request with USCIS. And then shortly after you get the case, we encourage you to reach out to your client. They are eager to get started. They are eager to know who they're going to be working with. And so giving them a call a couple weeks after you take that case and scheduling a first meeting will be what we would recommend next. Another thing that we encourage you to do shortly after you take a case is really starting to think through the case as a whole. What is your role going to be as the attorney? What is your job going to be? What are you going to be doing? So really there are three, I would say, big pieces to your job as the attorney in these asylum cases. Number one is going to be filing the brief. This is where you're going to make your legal arguments. You're going to establish your client's eligibility for asylum. The second thing is your client's affidavit or declaration. This is really where you are going to be spending the bulk of your time. And this is where the meat of your work with client is going to take place. You're going to work through with your client their story. What was their life like back in home country? What were the things that happened to them that forced them to flee and to leave their home country and oftentimes their family and friends and everything they knew behind? What has their life been like here in the United States, and why did they still have that fear of returning? So what has happened in the interim? What do they think will happen if they have to return? All of that information should be contained in the affidavit. And then finally, the third thing that you're going to prepare is an annotated index. And in that annotated index, you are going to incorporate all of the supporting documentation that you are going to submit and prepare along with the brief and the affidavit. So in terms of what are you looking for in terms of supporting documentation, it's going to vary from case to case. But a lot of the things that you always should be looking for is you always need to establish your client's identity. So identity documents will be things that you will be submitting along with this application. Then again, depending on your client's claim, you're going to be submitting different pieces of evidence. So for example, if this is a political opinion case, your client was a member of an opposition political party and they were targeted by the government of their country because of their political beliefs and opinions, maybe they have a card that shows their membership in that political party or group. That would be something that you would want to submit in your case. If your client's case is premised on the idea that he was a taxi driver in Guatemala and he was targeted by the gangs because they wanted him to use his taxi to transport drugs for them, and his refusals to do so was what led him to leaving the country, does he have any evidence that shows that he was a taxi driver? Does he have any pictures of him with his taxi? Any pay stubs, any things of that nature? And if this is a case where your client was a victim of domestic violence and said she, went to the police on multiple occasions to make reports against husband and sought a restraining order, are those the types of documents that you have? If she has those documents, you're going to want to include those in your filing. Witness statements are also going to be really great critical pieces of supporting evidence. So if your client was somewhere, an event happened to them, other individuals, family members, friends were present, they saw what happened, you're going to want to try to get a statement from those individuals, and we'll talk in more detail about how you're going to do that in a little bit. And then country conditions evidence. So in a lot of these cases, I like to think to myself and pretend the adjudicator knows nothing about my client's country of origin. They've never heard a Guatemalan case before or a Honduran case. So it's my job to educate them through country conditions evidence about what is the landscape like in this country? What is gang violence like in this country? How do the police respond to domestic violence complaints in my client's country of origin? And make sure that the court has that background knowledge so that my client's claim makes sense in context. And then finally, in some of the cases, an expert might be really important in terms of establishing your client's eligibility. Maybe this is a case where your client is from a really small indigenous Guatemalan community with a Mayan system of law that takes place, and it's something that is uncommon and a lot of people don't have knowledge about. Maybe you can't find a ton of country conditions about, but an expert has studied this region of Guatemala. It might be really helpful to have that expert opine and add some information in your case. So COVID, just as a last word from me now, has definitely had a huge impact on immigration cases and on the timing of immigration cases. So just to give you kind of a little brief overview of what's been going on, obviously everything was shut down for a little while. In June of 2020, the asylum office did reopen and they started having interviews again at the asylum office, but albeit on a much more limited basis. Because of COVID restrictions, they wanted to limit the number of people that were present in the asylum office at a time. And so definitely we saw things slowing down. In July of 2020, we did see non-detained merits hearings resume in Chicago. The merits hearing is basically the asylum trial in immigration court. So those did start up again in July 2020, but again, there were a limited number of hearings that were moving forward. A lot of them were being canceled to limit the number of individuals in the courtroom at a time. And so, you know, again, this increased backlogs. And then something called master calendar hearings or status hearings, really short little hearings where clients basically just have to show up in court. We're not going forward at all. To this day, there are still no master calendar hearings going forward, and we're still seeing a lot of hearings canceled with very little notice because only a certain number of judges are sitting every single week. So half the judges are on, half the judges are off. And then we're also seeing that some of the immigration judges or the IJs are moving to wanting to have WebEx or video hearings. And because of all of these things, we're just seeing backlogs increase a little bit. So that being said, we're going to move on now, and Dahlia is going to talk to you a little bit more about working with your client.
Hi, everyone. So as Rachel said, my name is Dahlia. I'm one of the attorneys on the Asylum Project, and I'm going to be talking to you a bit about working with your client. So hang on just a sec while we get the PowerPoint up. Let's see here. Sorry about this. We'll have it up in just a second. Okay, so, okay. So working with asylum seekers can be a bit different from what you are typically used to in working with clients. So some things to remember is that when you're working with asylum seekers, you're going to be talking to them about their lives, their you know, their experiences, some of the most traumatic and difficult things that have ever happened to them. And so, you know, it's important to be mindful of that as you're asking them questions. You know, it can be difficult for them at first to talk about these things. Also, asylum seekers are often in some very vulnerable positions when they come to the United States. They usually have had to flee with very little notice. They don't have much prepared, and so they can be stuck in unstable housing positions, have difficulty finding or getting authorized for employment, and so they will often feel that their immediate needs like food and employment and shelter to be more important than their asylum case. It's important to bear that in mind, and also to be sort of patient with them as their lives can often be a lot more complicated than we necessarily realize. Additionally, because of histories of trauma and living through violence and things like that, if you're working with a family, family dynamics can get complicated, and that is something that you're going to want to bear in mind as you're working with your clients. As you're going, hold on a sec. Don't know.
We're just switching the PowerPoint, Dahlia. You can keep going.
Okay, good to know. So while you're working with your clients, it's a good idea to keep the big picture of what you're going to be working on in mind. So Ashley, can you go to the next slide? So these are, as Rachel was talking about before, these are sort of the three big pieces of your asylum case. There's going to be your client's affidavit, the legal argument, which is going to be in your brief, and then all of the corroborating evidence that you're going to provide to either the court or the asylum office. So those are important things to keep in mind as you start talking to your client to build your case. Next slide. During the first client meeting is going to be really important for building rapport. We have some, general suggestions for things to do during the first client meeting. It's going to be important not to start straight off with business, sort of introduce yourself, who you are, get to know your clients a little bit, do some small talk. You're going to want to explain, if there are multiple people working on the case, you're going to want to explain everybody's roles, reassure the clients about confidentiality. You also want to be sure to be meeting with people one person at a time. So if your client has family members with them or anyone there for support, meet them, chat with them a little bit. But then when it comes to talking about, logistics or administrative things with the case, you're going to want to ask them to step out. And then, just start getting to know your client a little bit. Again, as I mentioned before, your client is going to have to talk to you about some very difficult and traumatic things. So building a sort of relationship and getting your client comfortable talking to you is going to be an important first step. You're also going to want to make a communication plan during your first client meeting. These cases can last for a very long time, and so having a plan for how to communicate, whether your client prefers phone calls, text messages, emails, whatever it is, sort of come up with that plan, come up with a plan for, how often you're going to check in, how often you want to meet, those sorts of things, and also make sure that your client is able to access transportation if you're meeting in person and figure out those logistics. You'll want to talk to your client about your plan for preparing the case. So what it is that you're going to be doing, starting with building the affidavit and what is involved with that, talking about how you'll gather corroborating evidence and the process, either going through an interview at the asylum office or a merits hearing at immigration court. And make sure that your client has a chance to ask any questions that they have at that time. Once you get through all of that, you can talk about your engagement letter. Make sure you explain it in simple terms so that your client can understand it, and have them sign any forms, the engagement letter, G28s, FOIA request, anything like that. It's really important in the first meeting that you don't talk about the details of your client's claim unless they specifically say that it's something that they want to do. The first meeting really should just be for introducing yourself and getting your client comfortable, and you can get into the details of your client's asylum claim at later meetings. Next slide. After your first client meeting, the first thing that you're going to want to do is to get a full picture of your client's immigration history. Unfortunately, in immigration proceedings, we don't get discovery. So the only way for us to get a full immigration history is to file a FOIA request with USCIS. If you're in removal proceedings, you do get expedited processing of the FOIA request, but still it can take some time. So it's important to file these as quickly as possible. There is a form on USCIS's website that you can fill out and have your client sign along with yourself to get access to what's known as your client's A file. That is their immigration file. Sometimes we need to get some information from the immigration court. There is a mechanism for filing a FOIA request with EOIR, that's the Executive Office of Immigration Review. If that's going to be necessary, talk to your NIJC point of contact and we'll see if what needs to be done there. Next slide. So as we said earlier, the affidavit is going to be the main part and the most important part of your client's case. And the bulk of your prep time is going to be spent interviewing your client and getting the information needed to put together a good, strong affidavit. While you're preparing the affidavit, something important to remember is that credibility is going to be crucial to having a successful asylum application. If the judge finds that your client is not credible, it doesn't matter if the affidavit and their testimony is meeting all of the asylum elements. If the credibility determination is negative, they're not going to get asylum. Judges make credibility determinations based on your client's demeanor, their candor, the inherent plausibility of their story, and crucially, consistency of the statements that they make in their affidavit, in their testimony in court, and at any other time in situations such as border interviews, if they've had an interview with the asylum office and been referred to court, things like that. So in that, it's really important to draft the affidavit carefully so that it appears both plausible and detailed, but also does not set your client up to be making inconsistent statements during testimony. And so that way that you can sort of preserve your client's credibility. And what I mean by that is that sometimes if you're overly detailed in an affidavit, so for example, you're putting specific dates like December 12, 2010, your client may not remember December 12, 2010 when they're nervous on the stand. So you have to balance the types of details that you're putting in the affidavit so that the story is clear and has, color, and you can, really understand what they went through without backing your client into a corner that might trip them up and cause them credibility issues later on down the line. Next slide. So just some basic tips for doing these kinds of affidavit interviews with trauma survivors. It is going to be a different experience than working with other sorts of clients. And so these are just a few things to keep in mind. You will want to meet often, but not for very long. These types of interviews can be very stressful for your clients. They will often be re-traumatized when talking about some of their past experiences with persecution. And so keeping them short will help them be able to be more forthcoming. You also want to be able to give your client some choices about how these interviews are going to go. You can offer them a choice of topics to cover in any given meeting. It's also important to explain why you're asking the questions that you're asking. That way the clients understand why the information you're looking for is going to be important. You also shouldn't expect a chronological story to come out at the very beginning. You should let your clients sort of tell the story in the way that they need to. Putting things in order and creating a chronology is then going to be your job. And then lastly, you want to bookend your interview. So you start out with something light and positive, and when you end, don't just end after your client's talking about torture or rape or something very traumatic. Bring the conversation back to some small talk, try and get them to smile or crack a joke or something like that to bring them back to the present moment where they are hopefully safe and a bit more comfortable than where they were when they were in their home country. So I'm going to pass it over to my colleague Bea to give you some more interviewing tips.
Hi everyone, Bea, Beatriz, either works. I'm the Pro Bono coordinator here on the Asylum project. So first I just wanted to go over some tips. Like Dahlia mentioned, context is really, really important. This is especially important when we're thinking about Nexus that we were talking about earlier. So we really want to dig deeper when we're having these conversations with our clients. So if they said that someone beat them up, we want to follow up with that and ask, what was happening at this time? What led to this moment? Did this person say something before, during, or after the incident? Was there a trigger towards this incident? How did this make you feel? It's also important when we're thinking about this that they might not have thought about some of these things before. And so we also want to tread lightly and allow them to have some space to think through these answers and some time to process their responses as well. And this links into ask why your client thinks something happened. So if they say that this person came home and started yelling at them and beat them up, we want to know, why do you think this happened that night, but also to you specifically? Would they have done this to just anyone else on the street they may have run into? We really want to link it back to our client. And we want to know, was this the first time that this happened? Was this a pattern? Had this person been drinking, taking drugs? We really want to get into the nitty-gritty. We also want to know how our client knows a particular statement of fact. So if they did something or didn't, there's likely a reason for it. So for example, if they said they didn't go to the police because the police don't help, there's absolutely a reason for that. So we want to know, how do you know this, right? How do you know police don't help? And why do you think the police wouldn't be able to help? Does our client live in a really rural area, so the police would take a long time to reach them? There's not enough police to cover that side of town. anything like that. Maybe the police doesn't help people like them, whether we're talking about a woman in a domestic violence situation, a certain ethnic or indigenous group, whatever it may be. It's important to ask these questions and see what your client might respond. Can we go to the next slide, please? Thank you. So I just wanted just to cover some pitfalls. So we're all going to be really excited when we start working with our clients and really just want to get going. And like we mentioned earlier, they're likely anxious as well to really just get going on their case. But we also want to remember with that first conversation, like Dahlia was talking about, to first just settle the tone and start a relationship with your client, because at the end of the day, we want them to feel comfortable and able to share these really, really difficult parts of their lives with you. So we want to create a space where they're going to feel safe for those moments when they inevitably might feel overwhelmed. So always remind them when you speak to them that it's all right to take breaks, to stop, get some water, go to the bathroom. If they ever need to move on from a section, that's okay as well. And also remember that there are things that you can do with them. So you could take a moment and have some breathing exercises together that grounds them back into this present moment and brings them back from the situation of trauma that they are living so vividly in their mind, and remind that they're in the present. So especially when we're thinking about the first meeting, but also then with all meetings when we start with some small talk just to get them comfortable. And like Dahlia was mentioning, a lot of survivors of trauma have likely had their control or their agency over a situation or time in their life taken away from them. So it's important to allow for them to take some of that back. And this can be done with small things such as letting them dictate the topic of conversation. So you can present them with the different sections of an affidavit that you need to work through and let them select for that day, where they would like to start, or even if you're thinking about future meetings. You could say, these are things that we need to keep working on. Where would you like to start next time that we talk? And that also helps them prep for that next call in a week, 2 weeks time, that they know in advance, all right, I know that I'm going to have to talk about this certain situation, and they can do what they need to do to emotionally prepare for that conversation, since it can be really difficult. Another way that you can give them an option for a choice, depending on their comfort level or their education level, it might be good to allow them to perhaps write something down first, that's an answer to a question or details about a certain situation. So for example, in the past, and especially with younger people, we've seen that maybe they haven't ever disclosed a sexual assault to someone, and it's really difficult for them to even verbalize what happened. And so it might be easier to first write it down and then kind of give you the piece of paper for you to read it the first time. So again, depending on their level of education or comfort, that might be a solution to kind of get the conversation started and get them to start sharing with you. Another thing that you can do, especially with children, is kind of like a family tree or a mapping of the people who were involved in their life back in home country, and allow them to highlight or signal in any way, smiley faces, check marks, hearts, whatever it may be, who brings up positive emotions for them as part of the support system, and who brings up really negative emotions, so may have been a source of abuse. And this can be helpful for you to further hone in on different parts of their claim, and also perhaps even find different people who could be, folks that you could ask for like supporting affidavits and have more supporting evidence for your claim. When we're thinking about tangents, a lot of times we really just want to focus, get the work done, really get going. But unfortunately, that's simply not how memory works for a survivor of trauma. So trauma affects the brain in many ways, and one thing that it does is that it compartmentalizes memories in your brain in a different way, and you might just have snippets of time, noise, emotion, whatever it may be. And so when you're speaking through a moment of trauma, you actually might recall other things. And so while they're talking to you and answering one question, they might recall something completely different, and they might start talking to you about that. And it's really important for you to allow that to happen so that you can also get that important information. So acknowledge this new subject, thank them, and appreciate that they took the time to share that with you, make a note of it, and then return back to it later. You can always come back to it and get more details once you have time to go back into that other question. And when we're thinking about chronological dates and time, especially when we're thinking about affidavits, it's really important to also remember with memory that your client is not going to give you a perfect story that starts from beginning to the end and just completely make sense. They're going to give you snippets here and there. So you're going to have to allow for them to give you new information that you go and edit and put back into the beginning, middle, or end, wherever it may be. It's your job to kind of organize it and put all the pieces of the puzzle back together and allow them to give you all of those different memories whenever it is that they recall them or feel comfortable sharing them, whatever it may be. And it might change, you know, when they keep remembering these different things or going over them. So truly allow for them to edit and work through that. Especially because dates can be really difficult, like Dolly was talking about earlier, and it can also bring a lot of anxiety and stress and even shame to someone when they can't remember a specific date, and all of these documents that the government is presenting to them, you know, really requires that they remember certain dates. So if you need to try to help your client approximate towards a date, you know, get creative. There can be different things that we can use here. So if someone had a kid in school or they were in school themselves, you can think about the academic calendar year. If you are thinking about birthdays, holidays, if someone you know, had a job or their family had a job related to farming, you can think about harvesting season versus planting season. Whatever it may be, you need to think about different ways that you can approximate. It was spring of 2019. Think about it if it was pre-COVID, if this person just arrived, whatever it may be, to kind of help them approximate. But at the end of the day, it's also really important to remind them that it is completely okay to not remember something, and completely okay to tell you, I can't recall. It's really difficult for me to recall, because that's actually also helpful to know that the trauma was so severe that it has impacted their memory that much that they can't recall certain things, whether it be dates or details. So allow them to share that with you, you know, acknowledge that that is totally okay. And it's better for them to be vague and honest in their responses and in the affidavit than to guess a random date, like Dahlia said, and then have their credibility questioned. Thank you. Wait, Dahlia, you're muted.
Sorry about that. So we're going to be going back to the hypotheticals that you saw at the beginning of the presentation. They are included in your handout. So let's go to the next slide. So here's a sample response to a question that you would have gotten from Norma, if Norma was your client. This is also included in the hypos handout, so you can refer back to it. And I'm going to pull up a poll here to see how you would, just to see how you would follow up after getting this kind of a response from Norma. So it'll take a few seconds. Okay, so I'm gonna close the poll now. And let's take a look at the results. So most of you thought that all of the questions should be asked in follow-up. And then the next group of next highest group was after you moved in with Carlos, how did he treat you? So I think the folks that hit all of the above, you're right in that, you know, all of these questions are things that you're going to want to get to eventually. But you don't want to, like, when you get that kind of a response from Norma, you're going to want to prioritize kind of your follow-up questions so that you can get sort of the most information out of her. If you ask right away, well, no one really said, what did Carlos say when he was abusing you only? But if you ask that one kind of right away, you may sort of take her attention away from the abuse and the treatment that she got and make it more difficult for her to recall details of that, which is going to be important later on. So the kinds of questions that you're going to want to focus on are, how did Carlos abuse you? Or, you know, in a different way, after you moved in with Carlos, how did he treat you? How did Carlos abuse you is probably a better follow-up question than after you moved in with him, how did he treat you? because in her initial response that you're following up on, Norma already said that in the beginning he was nice and then he started to abuse me. So a follow-up question like the first option might confuse her a little bit because she might feel that she already told you that he was nice at first and then he started to abuse me. So probably a good follow-up question that still gives Norma a lot of latitude to talk about, you know, how she felt and what was happening to her is, how did Carlos abuse you? But don't feel too bad, because all of these questions are things that you're definitely going to want to ask at one point or another. Okay. Next slide. Let's do another one. So remember the hypo about Christopher, and let's say that you're in an interview with Christopher and he gives you this response. How would you follow up with Christopher? Okay, I'm gonna close the poll now and let's take a look at the results. So most of you said that how did the cartel target you would be the best way to follow up, and I agree. So Christopher's saying that, you know, the cartel was targeting him, you know, to use his trucks, and so we want to know what that means. What did they do, and what did that targeting look like? A bunch of you also said, what did they say? Which is a bit of a misleading response to this question, because when Christopher's saying the cartel targeted me, we don't really know what that means. It could have been them calling him up on the phone and saying something, talking to him, you know, at his business or in the street. It could have been other things. There could have been, you know, symbols or notes or anything like that. So a better way to follow up would be the first option. How did the cartel target you? The other two responses, what date did the cartel first contact you and how many times did the cartel threaten you, are kind of in there to mislead a bit. So if asking what date the cartel first contacted you is that kind of very specific fact that that your client may have difficulty remembering, but also that is probably not good when you're first building up the affidavit. You don't want your client to get too focused on trying to remember specific dates, and instead you want to get more of the information about the persecution and things that happened to him. Same thing with how many times did the cartel threaten you? You know, it's a good thing to do is to first establish, okay, the cartel was targeting him. What did that look like? Then you can sort of start asking questions about how often that happened, whether it happened more than once. But how many times specifically may also be another thing that your client is not able to answer directly. So sometimes we're talking about a few instances of persecution or just a handful of threats, and some clients will be able to say it happened 3 times and be very confident about that. In other cases, we're dealing with a lot of persecution over an extended period of time. So asking how many times is really going to be difficult for your clients to answer. And instead, you may want to ask questions about frequency, like how often did you receive threats? Was it every week? Was it every month? That sort of thing, which, you know, gives your client a little bit more cover when it comes to an interview or a merits hearing, so that, you know, if the judge or DHS attorney wants to know how many times something happened, they can say, I'm not really sure, but it happened a lot, that sort of thing. Next slide. So now I'm going to talk a little bit about working with interpreters. Most of your clients probably won't speak English very well, and so you'll need to work with interpreters if you don't speak your client's language yourself. An important thing to remember is that the interpreter is only there to translate. You still are having a conversation directly with your client. So some basic tips are to set guidelines and expectations with your interpreter ahead of time. You want to make sure that during an interview, you're talking directly to your client and not to the interpreter. Asking short questions and avoiding compound questions is helpful when things need to be interpreted, because it helps avoid confusion. And you also want to make sure that your meetings are not too long and that you take breaks. That is both for your client and for the interpreter. Interpreting is very difficult, it's very tiring, and your interpreter will need a break. So now we are going to show a brief video about working with your interpreter. All right. We're running a little bit over time for this section, so we're going to skip the last hypothetical. We're now going to take another 5-minute break. So we'll be back at 1:55, and Rachel will talk about preparing your case.
All right. Hello, everybody. Welcome back. We are going to go ahead and start our last section of the training now, which is about preparing your case. So Dahlia talks a lot about the affidavit in the last section. And so when you're putting together this affidavit, which we have said is going to be the most important piece of evidence in your case, we want you to keep in mind a couple of things. And, go into this knowing that the bulk of your time is going to be spent working on this document. One thing we would encourage you to do is, as soon as you get this case, even if the case is set for a hearing out in 2022 or 2023, start working on the affidavit with your client right away. You'll have those introductory meetings, you'll start getting to know your client, and then you really want to start in on the work on the affidavit. Don't wait a year, don't leave it, because you're going to have to keep coming back to it and revisiting it and fleshing it out in more detail as you go along. So make sure you spend some time here and spend some time here early. So the main things that we like you to keep in mind, number one is it should sound like your client. So when you're talking to your client, if your client is a very well-educated, older man, it should sound like that. If your client is a 16-year-old indigenous Guatemalan boy who has had very limited education, it should sound like that. So it shouldn't sound like a lawyer. It shouldn't sound like a lawyer wrote it, even though a lawyer is writing it. It shouldn't have any cites to tabs or exhibits or things like that. It should literally seem like your client is talking when you are reading through that affidavit. So try to keep that in mind. Another thing that Bea mentioned is, crafting the events in chronological order. So think about this as a story. Obviously, it's an advocacy tool story. It's a story that needs to establish your client's eligibility for asylum, but ultimately it's a story of their life. It's a story of the beginning of their life, their background, where they grew up. It's a story of all of the things that happened to them that sort of forced them to leave their country. It's the story of them coming to the US and their life here. And it's also the story of why they're afraid to go back. What has happened since they left? Have threats continued? Have other things continued to transpire? What is going on back in home country that is making them afraid to go home? So really telling those stories in that kind of a chronological order is going to be really helpful for the reader, because it's very difficult to jump back and forth from 2000 to 2009, back to 1996, over to 2008. It makes it very difficult to follow. So thinking about those things in chronological order, as Bea mentioned, using a timeline can be really helpful for you. It can be really helpful for your client to try to put things in order and keeping those things there. And then also providing necessary background information. So in a lot of these cases, in a case where maybe your client's case is a political opinion claim, your client was part of a political party and they were targeted by the government because they were a member of this political party, well, we're going to have to give some background about conditions in that country, about that political party, before we can really understand your client's claim. If your client was, threatened by gang members because, he refused to join and he fled to the United States right afterwards, well, we're going to have to understand, first of all, what do we know about this gang? Why is that so scary that you refused to join a gang and you had to leave the country immediately thereafter? So providing that background information in the affidavit is something you're going to want to do. Always thinking about the 5 W's and H: who, what, where, when, why, how. We want to know all those things. Who did this happen to? Where was client at the time? Why did they target your client? Who else was present who could potentially provide a supporting affidavit? And, how did your client manage to escape? So thinking about all those things and incorporating those things. And then really when we read through these affidavits, because we'll ask you to send them to us for review, we're going to be looking for the asylum elements. So all the things that Ashley walked through with you. Do we know what harm this person suffered? Do we know who was the persecutor and who targeted your client? Do we know why your client was targeted? Do we know if your client went to the police or went to the government for assistance or help? And if they didn't, do we know why they didn't go for help? And then do we know why your client has a reasonable fear of return? So all of those things should be incorporated and included. And then finally, you're going to want to think about length and detail. So in terms of length, if you send us an affidavit and it's 2 pages long, I'm almost 100% positive that it's not going to be long enough. There's no way that you're going to be able to include all of the things that you need to include to establish your client's eligibility for asylum in that short of amount of space. But you also don't want to overpaper, right, and give them a 50-page story where we're going to get lost along the way. It's really going to be probably in the 8 to 15-page range would be something probably reasonable. And obviously that's going to vary depending on your client and your client's claim. Detail, Dahlia talked a little bit about, and we'll talk about a little bit further in another slide. We want enough detail to make the story compelling, but not too detailed that we're pinning our client down to some details that don't really matter and creating credibility concerns for them when they have to testify at a hearing, worrying about, are they going to testify consistently with that affidavit that we prepared. And then I would say the final step that you're going to take, and this is going to be a crucial one, is going to be checking for consistency with other documents. So we talked about the FOIA and trying to get a record of all of your clients' interactions with other immigration officials. What statements did they already make? After you have a draft of that affidavit, you're going to want to cross-check those documents and see if there are any inconsistencies. And if there are, you're going to want to talk to your client about them. A lot of times there's a reasonable explanation for why they didn't disclose something earlier, why things are inconsistent. Maybe there was a translation issue. Maybe there could be a million reasons, but it's definitely something we want to know about. You're also going to be preparing affidavits from other witnesses and family members potentially, and we want to cross-check those as well, just to make sure that everything syncs and lines up and we're not creating any credibility concerns for our client based on the documents that we're submitting on their behalf. As Ashley flagged for you, one of the handouts that you have, I think is super helpful. It's just a lot of advice about preparing affidavits from other pro bono attorneys. They've been in your shoes. They have done the exact thing that we're asking you to do. They have a lot of really, really helpful tips in there. So I would highly recommend and encourage you to take a look at that. And then we also have a whole nother training just on preparing affidavits, and you can see there's a link to that in the bottom of this slide. So this is just a sample of what the first page of an affidavit will look like. Essentially, every time you're drafting an affidavit, at the very beginning, we want to have an introductory paragraph. In that paragraph, we basically just want to have a very brief overview of who your client is, what country they're from, and why they felt they had to flee here. So what is the essential basis for their asylum claim? After that introductory paragraph, we recommend breaking up the affidavit into subsections. Otherwise, reading a 10-page document with no subheadings is a little bit tough. So think about using those subheadings to break things up temporally, subject specifically. So you can see here we have my background or family background listed, where we're going to give some background about who our client is, where they grew up, personalize, humanize our clients a little bit in this section. Then we can get into, instances of persecution. Then we can get into their flight to the United States. Then we can talk about their life here in the US. And then finally, we can talk about why they're afraid to return. So the affidavits should walk through those different sections. And here's just a couple examples. We can always provide you with additional samples if you'd like. So here's an example of some things that we see often that we want to flag for you to be careful of. So first of all, we wrote language at the top. And so you see, I was persecuted because I belong to a group of Salvadoran females in relationships they are unable to leave. If I read that sentence in an affidavit that was sent my way, I would think to myself, that does not sound like something one of our clients would say. Our clients don't really use the word persecuted. That's really a legal term that we use in our writing in these asylum cases. And we also clients don't talk about themselves in terms of their membership in particular social groups. So we might see something like, my husband abused me or beat me because he thought that he could because I was his woman and I couldn't leave him. Something like that would sound a whole lot more like a client. So thinking about the language you use and the voice, really needing to sound like your client. And that second sentence here we include because it really talks about really too much detail. So my problems began on May 1st, 2010. Oftentimes we don't include very specific dates for clients unless it's a critical date in their life for some reason. Maybe they do remember the specific date because it was their dad's birthday, or because there was a political protest on that date and we found country conditions documents that support it. But otherwise, we can be a little more general. In May of 2010 or around May of 2010 would be sufficient. And then again, in the next part of the sentence, when 3 gang members driving black motorcycles accosted and harassed me. Well, you know, maybe client's going to get tripped up and they're going to say 4 gang members or 2 gang members at trial, and we don't want to create credibility concerns. So really thinking about what details are important for us to include, which ones can we omit, and which ones can we generalize on. So we may just want to say several gang members. We may just want to say vehicles instead of black motorcycles, so they don't say a truck later or something else that could create credibility issues. So when you're getting ready to submit your materials, either to the asylum office or before your court hearing, we'll ask you to send the affidavit and also your brief or legal memo over to us for review. And I would say the 4 things that we look for and we sort of have to push back on a little bit. Number 1, as I've talked about already, is voice. We really need it to sound like your client is talking. The court's going to be looking for that. The court wants to hear your client's voice. The second is, does it incorporate and include all of the asylum elements? 2 that I often see missing are that government unable and unwilling to protect. So oftentimes if client didn't report to police, they just don't say anything about it. And we're going to want to include something in there about why client didn't bother to seek government assistance. Maybe they knew the government wouldn't help them. Maybe they feared that if they did go to the police, you know, the gangs would retaliate against them and harm them even further. So we're going to want to include something about that element in the brief. And the second one is the fear of return. So oftentimes, you know, we see that clients don't talk about that, but remember that asylum is based on fear. Your clients left and fled their countries because of fear, and they're afraid to go back. And so we need that to come through in the affidavit. The third is internal consistency with other documents. So again, if we are going to cross-check with statements they made at the border, or we're going to look at the different affidavits that are submitted by family members and cross-check those, we're going to want to make sure they all track and align. And then finally, have you provided enough context and background so that we can really understand your client's claim and understand why your client needed to flee? Does it all make sense? Next most important thing that you're going to do is seek corroboration for your case. So, you know, the standard is ultimately in asylum cases is that the testimony of your client standing alone should be sufficient to sustain their burden of proof in an asylum case. However, the adjudicator can require corroboration unless your client doesn't have it and they cannot reasonably obtain it. So that's the standard. So what you're going to want to do is get corroboration for every element of your client's asylum claim, or you're going to want to explain why they couldn't get it. So for example, let's say that your client said that she was threatened by gangs, and so she went to the police and she filed a police report. Well, of course, the court's going to say, where's the police report? And they're going to want to see it. If your client doesn't have it, then you're going to ask client, can we get a copy of it? And if client says, no, we can't get a copy of it because I'm afraid to ask my family members to go to the police station because the gangs watch the police stations, and I'm afraid if I send my family members there, the gang members will come after them too. Well, then we're going to include that in client's affidavit so that we are explaining to the court why your client can't get it. Every time that happens, you're going to want to make sure you include language in the affidavit to support. This is a chart that we often look at where it's really just for you to take a look at and think, what kind of corroboration can I get? And I think there's a million different types of corroboration that you can look for. Every case is going to be different. Some cases you're going to really focus heavily on certain pieces of evidence. Other cases, you're going to focus on completely different pieces of evidence. So in every case, you're really going to look for some country conditions evidence, which is going to provide information about your client's country of origin, give them a lay of the land, give them some information about what is happening in your client's home country, both back when they fled their country and also what are current conditions in your client's country. You're also going to want to have some client-specific information. So if client was abused and suffered, physical damage and abuse, maybe they have photographs or pictures. You can also try to get them a forensic medical examination where the scars and injuries on their bodies can be documented by a physician. We do have referrals and information that we can give you if that's something that will make sense in your client's case. Other clients haven't suffered any physical harm, but they've been really mentally traumatized by what has happened to them. And those individuals suffer from depression or anxiety or PTSD or have had nightmares, and they really need counseling and therapy and other support systems to help them. So we also can help you with referrals to counseling services if that seems like something that will really help your client. And in those instances, we can get a mental health evaluation and we can submit an affidavit from that counselor or therapist along with your client's application, which can be really helpful to prove up emotional harm in your client's case. Also, witness statements are going to be critical. So oftentimes, if somebody else was there when things happen to your client, we're going to see if we can get a statement from them. And the way that we usually obtain statements from individuals that are not in clients' home country, so oftentimes clients' family members are still back in home country. So how we obtain those is we talk to client, we ask for phone numbers and contact information for those family members, and then we reach out to those family members, we call them, we ask a bunch of questions, we draft the affidavit ourselves in-house, and then we ask that family member just to write out a short statement, basically letting us know that, you know, they reviewed the foregoing affidavit and everything is true and correct. They take a picture and they send it back to us, and we have them take a picture of their ID usually and send that to us, and we submit those along with the affidavit that we drafted on their behalf. We also have family members here in the United States, but sometimes they're undocumented and they're afraid to provide statements in cases because they don't want to bring themselves to the attention of immigration officials. So we often work with them as well and let them know that they can provide a witness statement. They don't need to give their address or identifying information. They don't need to come into court to testify. But definitely, you know, sometimes them providing a statement in support of what happened, if they were a witness to these events, can be really important and helpful in their family members' cases. So just kind of keeping in mind all of these different things that you can be looking for. So how do we get corroborating evidence? I would say my number one tip is talk to your client. What does your client say? What, you know, who can you talk to? Who do they think could provide helpful information? Maybe there were newspaper articles about events that your client participated in or was present for. Maybe they're aware of other sources that you are not. So talking to them about how can I get this evidence? And then if your client does provide you with pieces of evidence, they provide you with documents or other things, the one thing that we like to stress is making sure there's a chain of custody in place. So talking to your client, if they give you a document, how did you get this? Well, somebody mailed it to you. You can ask them for that mailer envelope so you can see that. We just want to make sure that everything we're submitting in these cases is going to be authentic and true. Sometimes I think clients feel stressed to provide additional evidence in these cases, even though we know the standard is, you know, your testimony alone should be sufficient. They sometimes feel pressure to provide additional evidence. So we just want to make sure that everything is authentic. If you have any doubts about it, don't worry about it, leave it out. One other great thing about immigration court is that the federal rules of evidence do not apply. So you can be really creative and you have a lot of latitude in terms of what you can submit in these cases. So for example, if your client, you know, was in a domestic violence situation and has continued to receive threatening text messages from their partner, take screenshots of those text messages. You can submit that as evidence in your case. If you have a political opinion type of case and your client has continued to be vocal about their political beliefs and has criticized the government on their social media page or on Facebook or whatever, take screenshots of those posts and submit those in your case. So all evidence is pretty much fair game in these types of cases. As I mentioned in the last slide, we highly recommend drafting supporting affidavits yourself instead of just saying, hey, can you get an affidavit from mom or from your cousin or whatever? Because oftentimes, if you just ask people to draft an affidavit, it's not going to include the information you need it to include. It's not going to be responsive to the asylum claim. If you have the ownership and control of crafting that affidavit, it's going to be a lot more helpful and supportive in your client's case. And then a final note is if you are submitting any foreign documents, any police reports that are in Spanish or other languages, any other documents that are not in English, you will need to provide a translation into English and submit that along with your filing for the court. So I'm going to skip our hypo and keep it rolling here so we can get you guys out of here on time. And so we're going to switch over and Dahlia is going to finish up and talk about presenting your case.
Again, so let's go to the next slide. When it comes time to present your case, your you're going to find yourself in one of two positions. You're either going to be going to an interview at the asylum office, or you're going to be going to a hearing at immigration court. So there are a couple key differences here. At the asylum office, the interviews are non-adversarial. So that means that as an attorney, you have more of an observer role. The asylum officer is going to be asking your client all the questions, and you will be able to ask some follow-up questions or make a statement at the end. But the primary fact finder in that case is going to be the asylum officer, and they're going to be asking most of the questions. There won't be any cross-examination or anything like that. Move over to the immigration court, and this is going to look much more like a trial. So you are going to do direct exam with your client. The Department of Homeland Security is going to do cross-examination. Some judges like to ask questions as well. Some judges will interrupt and ask questions. Sometimes they will ask their questions first, and sometimes they wait until the end. So preparing for each one of these scenarios is going to be a little bit different. Next slide. One thing that you're going to need when it comes time to go to your interview or your hearing is that you'll have to put, this is when you have to put together your legal brief or your cover memo if you're at the asylum office. Things to keep in mind while you're preparing your brief. You want to keep it brief. The immigration court has a 25-page limit on all legal briefs. The asylum office doesn't have those kinds of page limits, but it is still good practice to keep it as short as you can. You want to maintain the interest and attention of the officer with your brief, and you also want them to read it. And so if it is, 60 pages long, there's less of a chance that they're going to read it all the way through. When you are laying out your legal argument, you want to be sure to be very strict with yourself about dealing with each of the different asylum elements that Ashley talked about individually, and not to conflate them or talk about them at the same time. This can be a little bit tricky sometimes because there is often a lot of overlap between the different elements, and there's certainly, overlap with the facts that you're going to use to prove up each element. So for example, proving membership, like the facts that you would use to show membership in a particular social group might be the same or very similar to the facts that you're going to use to show Nexus. But even if it feels a little bit repetitive, it's really important to separate out each element individually. As Ashley mentioned earlier, you want to focus on Seventh Circuit case law. It is your friend. You should be able to find most everything that you need under the Seventh Circuit. And because the state of the law here is a little bit different than with other circuits or with the Board of Immigration Appeals, it's a good idea to stick to Seventh Circuit case law as much as you can. You are going to want to send your brief to us 2 weeks before your filing deadline so that we can review it and give you feedback and still have enough time for you to do final preparations and everything. If you want to send it to us earlier, we would always love that. And then lastly, in your brief, you're going to want to preserve all arguments and claims to relief. Sometimes certain arguments may be weaker than others, but if they're viable or plausible, you want to put them in there even if you're not going to spend a whole lot of time on it. That way the argument is preserved if you need to bring it up again later. Next slide. You also need to present all of your corroborating evidence. So everything that Rachel was just talking about, your affidavits, supporting affidavits, any kind of primary evidence and all of your country conditions is going to come together in a big packet. And so you're going to want to include on top of that what's called an index of documents. And it looks kind of like what is on this slide, basically saying, showing which tab you're going to find each piece of evidence at and what the evidence is and at what page number in the packet you'll find it. When it comes to country conditions, you're also going to want to annotate this index. So you'll need to highlight, relevant portions of your country conditions information and then include important quotes in the document index. That way, if the asylum officer or the judge only reads your document index, they're still going to be getting the most important information. Next slide. And especially if you're in immigration court, you're going to want to pay attention to your filing format. The immigration court has a practice manual that walks through all of the requirements. It's going to be really important to read that. We have some information about it in our manual as well. As I said, you're going to want to annotate your index and highlight the important info in your country conditions reports. You need to have tabs on the right-hand side for each of your exhibits. You need to consecutively paginate everything that you send over to the court, and everything needs to be 2-hole punched at the top and printed single-sided. Also, you definitely want to remember to serve ICE counsel when you're filing in court. You don't have to do that at the asylum office, but you do have to do that with immigration court. If you don't provide a certificate of service and serve ICE counsel, the court will reject your filing. Next slide. So as we talked about a bit earlier, the case timing, it can vary a lot, especially due to COVID. And the length of time that you will wait for a hearing and when your hearing gets scheduled will vary depending on the case and the judge that you're in front of. We've been seeing certain cases take a really long time to get scheduled, and sometimes cases get scheduled with not a whole lot of notice, just a couple of months. So it is going to be really important to keep checking the online case status portal to see if your client has been scheduled for a hearing. That way you don't miss any important deadlines and you don't get caught out at the last minute trying to put everything together. Next slide. The other side of that is that sometimes cases can pend for a really long time. And if that's the case, it's still going to be important to maintain contact with your client. You will have worked with them to build up a relationship and start working on their affidavit, and you want to keep that up even if the case is going to pend for a really long time. While your case is pending, you can use that time to gather other evidence. As Rachel was talking about, you can talk with your client, figure out what kind of corroborating evidence is going to be important, and start gathering it, especially if you're trying to get evidence from client's home country. This can take a really long time. And so the earlier you get started doing that, the better. If you need to do a mental health evaluation or a forensic medical evaluation, you can use the time that the case is pending to get those done. If your client is in immigration court, you're going to have to request a biometrics appointment. We have instructions on how to do this on our website. You can also talk to your NIJC point of contact if you have any questions about it. But if you have not requested a biometrics appointment by the time your case goes to a merits hearing, the judge is empowered to dismiss the case. So we want to make sure that you at least request it. Biometrics are required for any final decision in an asylum case, and so this can be really important. Also, while the case is pending, your client will may become eligible for work authorization. And when and if your client becomes eligible will be sort of a case-by-case determination depending on your client's specific situation and how long their application has been pending. Let's go to the next slide. Work authorization is very important for all of our clients. It can be a life changer in terms of their ability to find employment and find employment that pays, reasonably well, their ability to support their family and survive during the long process that asylum often is. Work authorization can get quite complicated, so when you take on a case, we will give you some information about your client's work authorization eligibility in the case file. If your client is eligible for work authorization or you have any questions about it, we have an employment authorization FAQ sheet on our website, and you can also talk to your NIJC point of contact. Next slide. Lastly, you're going to want to prepare your client for their asylum interview or their merits hearing. When you do that, it's important to explain the process that your client is going to go through. If it's a merits hearing, that there will be direct examination, cross-examination, closing arguments. And if it's an asylum interview, make sure that your client understands that you're going to have a more limited role and they're really going to be having a conversation with the asylum officer. When you're preparing for the interview or hearing, we recommend 3 prep sessions. One session that is a full prep where you ask questions and you can talk in detail about the way that your client has responded, if there are things that they need to work on, those sorts of things. We recommend a second prep session to be a really tough one so that your client is prepared for really aggressive questioning or difficult questioning. And then a third one close to your interview or hearing to build up your client's confidence. If your client is in immigration court, it's also important to practice cross-examination so that they are prepared with how to answer those types of questions. It's also very helpful to explain to your client, the legal arguments that you're making and the theory of the case so that they understand what they need to prove and how you're presenting the case to the asylum officer or to the judge. If your client understands the way the case is being presented and which facts are going to be most important, they're going to be better able to answer questions. You also want to manage your client's expectations so that they know what to expect and empower them to advocate for themselves while they're in the interview or in the court hearing. It's important to sort of remind them and make sure that they understand that if they don't know the answer to a question, they should say so, or if they don't understand a question, they should say so and ask for clarification. Next slide. So after the merits hearing or interview, either asylum will be granted, in which case, take a victory lap, celebrate, let us know immediately. After asylum is granted, clients have 30 days to access some asylee-specific benefits. And then there are a few, last things that you'll need to do, like obtain an I-94 to prove asylum status for your client, get access to their social security card, or an unrestricted social security number. And then if your client has derivative family members in their home country, you can refer them to us so that we can start the process of petitioning for them. If asylum is denied, don't panic. Reserve your right to appeal. You'll have 30 days to file an appeal with the Board of Immigration Appeals. And then again, let us know immediately and we'll talk about filing an appeal if that's appropriate. Next slide. So that's about all that we have for the training here. I think Ashley is just going to close things off. You're muted, Ashley.
Thank you all for joining us today. And as we said, we'll get you out right here at 2:30. If you want to go to the final slide here. Thank you. As I mentioned at the beginning, we do really appreciate your feedback. So if you would take some time to complete the survey, you can either use the QR code here, or I'm also putting in the chat a link you can use directly. I've also included in the chat a link to our current case list. So if you do not currently have an NIJC asylum case and want to get involved, and you're one of our partner at one of our partner firms, we encourage you to take a look, and then you can reach out to us with any questions that you have. In the coming days or probably early next week, we'll send a follow-up email that will include your CLE certificate, a copy of today's PowerPoint, so you'll have access to the PowerPoint and some of the links that were included within it. And again, you can download those handouts before you go if you want to access to any of those materials in the future. So at this time, I don't think we have any more questions, so we will let you go on your way, and thank you again for participating.